Hi, Chris.
Bob?
As you know, the decision out of the Supreme Court came down in June in the Wal-Mart case. Got some fair amount of publicity, but I'd like to know from you, what do you think is the most significant aspect of that decision?
I think there are a couple of very significant aspects to the decision. To put it in context, we have to realize that this class action was one for declaratory and injunctive relief primarily, rather than for damages. And so it was a B2 type of class action rather than a B3. I think what's significant about that is in a B3 class action, in order for the court to determine that a class should be certified, it has to make a determination based on a rigorous analysis that common issues predominate over individual issues, and that the class action device is the superior device for adjudicating the claims. That's not a requirement in a B2 class. Now, there is a requirement that there be commonality and typicality, but prior to the Wal-Mart decision, courts in the federal system were really split on how to interpret those requirements. And a number of courts looked at commonality almost as a throwaway requirement. If there was any common issue that was alleged by the plaintiffs bringing the suit, some courts would say that's sufficient to satisfy the requirement. And given that there was no predominance requirement, a declaratory injunctive class could easily be certified. The Supreme Court in Wal-Mart takes a very different view of the commonality requirement, basically holding that a common issue to satisfy the rule has to resolve an issue that is central to the validity of each one of the claims of the class in one single stroke. And they go on to say it's not the question that must be common, but the answer to the question that must be common. That really breathes new life into the commonality requirement in a declaratory and injunctive situation. And I think that is a very significant aspect of the decision. There is a second way as well in which I think the decision is quite interesting. The commonality point I just made was a 5-4 split in the Supreme Court. But the second point that I'd like to mention went off 9-0. And you don't usually get a unanimous Supreme Court on something like this, but they did. And that second issue involved the situation of whether a plaintiff bringing a class action primarily for declaratory and injunctive relief, but also seeking damages. And that was the case in Wal-Mart because they were seeking back pay as well as a cessation of the activity that they were challenging. That issue was, well, if your primary relief is declaratory and injunctive, but you also want damages, can you bypass that predominance requirement I talked about for damages by saying that's just ancillary to the suit, and as long as you satisfy the requirements to get declaratory and injunctive relief, can you kind of just slip in the damage claim as well and not have to satisfy predominance? A number of courts have allowed that kind of thing to happen. Not all courts, they were really split on that. The Supreme Court 9-0 said no. If you're seeking damages, whether it's part of your claim for declaratory and injunctive relief or whether it's brought separately, the damage aspect has to meet predominance except in rare instances where it's truly incidental. For example, everybody paid the same fine, and so predominance is not going to be an issue anyway. Short of something like that, if you're seeking back pay or in an antitrust case, if you're seeking damages, doesn't matter if you're trying to get an injunction, if you're trying to get damages, you have to satisfy predominance.
Do you think now that it's going to be easier to satisfy that B3 requirement if you've gotten past the B2 commonality? I saw that the dissent, for example, has said essentially that the majority has infused the B2 commonality with the B3 predominance principles.
It's a great question. I don't think the majority's decision conflates the two. I think predominance is still a separate requirement in a B3 class compared to commonality. But I would agree with your point to the extent that it brings them closer together. As I mentioned before, prior to this decision, a number of federal cases looked at the commonality requirement as almost an easy throwaway. if the plaintiff could postulate any common issue. Didn't have to be central. No one cared about whether the answer was critical as opposed to the question. That was enough. And so B3 predominance was a very, very different consideration. Now, with the much tougher commonality, I think if you satisfy commonality, you've gotten somewhat down the road of satisfying predominance, but I don't think you've gotten all the way there, because you not only need common issues as the Supreme Court has now defined them, but you need them to predominate. So while I think it's gotten closer, I don't think it's the same.
Let me ask you about another aspect of the decision that hasn't gotten as much publicity, and that's Daubert analysis. Daubert analysis basically has to do with whether or not an expert is qualified to give particular testimony. In this decision, the court comments on the use of Daubert in a class action context. Do you read anything into their comment on that?
I do. I do. I think the decision generally has given more definition to the whole rigorous analysis approach. And I think as part of their commonality analysis, they're basically saying that just because a plaintiff comes up with an approach that it plans to use, that does not mean that a court necessarily has to credit that approach. I think they go on to say even if the plaintiff intends to try to satisfy the approach through an expert, that's not the be-all, end-all. It's not as simple as we have an expert, we have an approach, that's all we need to do to satisfy the rigorous analysis test. The court can delve into that and ask the question, in the context of this case and the issues as they frame up, is that really going to work to show that the resolution of the common issue, the answer to that common issue, is going to drive the case forward? And I think in connection with that, on your question regarding Daubert, while I don't think the court actually comes out and says it, they hint very strongly that a Daubert analysis can be part of the rigorous analysis inquiry. And if a defendant, for example, wants to challenge not only the approach that the plaintiff is going to try to put forward to satisfy a class, but whether or not the plaintiff's expert on class certification has a reasonable basis under Daubert for stating opinions, I think this opinion of the Supreme Court comes very close to saying that is the type of thing that trial courts are going to need to look at before they certify a class. So I think we will see more Daubert challenges in the class action context.
There's another 23A element, typicality, that has also generally not been rigorously approached by plaintiffs or defendants in any particular way. Do you foresee that that's going to be the next battleground, will be the typicality element?
It could be. I mean, the analysis that the court has made on commonality, a lot of it, I think, could easily apply in the typicality context. Although, if you've got to meet commonality under this standard, which you now do in the federal courts, I'm not sure if you add an additional requirement similar to it on typicality, it'll make all that much of a practical difference. I do see those things as related, and wouldn't be surprised to see new life bred into that as well.
Okay. Thank you very much.
Thank you.